Advocate Gcaleka, good afternoon. How are you, ma'am?
Good afternoon, Chairperson, and good afternoon to the honourable panel members. I'm very well, thank you.
Good, thank you very much. We wish to thank you for accepting the invitation to come and have these interviews with the colleagues. How we do it, we afford the candidate 5 minutes to state why he or she should be considered for nomination as a public protector. You are already a deputy public protector, acting public protector, so we are aware of that. And after that, you will then come back to confirm the disclosures that you have made in the questionnaire and check if there is anything else that you want to disclose or add. Let's start with the 5 minutes presentation, and the 5 minutes starts now. Over to you, Deputy Public Protector.
Thank you, Honourable Chair, and good afternoon once more to the honourable panel members. As per my CV, I have an LLB degree. I have a master's in commercial law, and I'm currently developing myself in the field of cybersecurity governance. This is because of my passion around the area of cybersecurity governance. I started off my career in the National Prosecuting Authority. I think the highlights of my career in the NPA was serving the members of the public. I started off as a trainee prosecutor. However, I managed a court where I dealt mostly with matters of domestic violence, and that has been where I learned on the plights of the people, particularly those of women within our country. I went on to prosecute in the regional court, where there too I was a specialist prosecutor in sexual offences, and at times I would also do matters of fraud within the court. What was more peculiar was also being able to pick up some of the economic factors which affect our countries. I also prosecuted in the Western area, which indeed today we still find ourselves under the same challenges of illegal mining in our country. I personally prosecuted those matters and also had taken the opportunity to go down into the mines and see the conditions under which the illegal miners live. And thereon also we had discovered that some of these illegal miners were trafficked into the country. It is still the major challenges that our country is going through. As a result, in my current acting position, I have also engaged the Ombudsman of Lesotho to discuss the circumstances around this and see how can we assist one another to resolve at least the administrative challenges that permit this kind of movement between our two countries. I then moved on to prosecute in the High Court. There I had extensive exposure, not just in the criminal court, but also in the motion court. And I have also, the time I left the NPA, I was the Senior Deputy Director of Public Prosecutions, but I still maintained prosecuting because litigation was my passion. That really exposed me at a higher level on legal work, drafting not just matters for the High Court, but matters for the Supreme Court of Appeal and Constitutional Court, where my colleagues were appearing. I would be the checking officer in respect of those matters. That has then equipped me for the further roles which I took of a deeper understanding of the law, but also on the challenges that are faced by the people of South Africa. I took up the position of being an advisor, for which I had been an advisor to 2 different ministers, advising on the law, on governance and administration. In that position, it actually exposed me to the work of the executive authority. I was basically the sole advisor in respect of those issues and had to abreast myself on deeper matters regarding the governance in our country. I worked in the departments of Home Affairs, as well as Finance and the Department of Public Service and Administration. There was a period through which I also conducted some workshops regarding gender-based violence, assisting the Department of Community Safety in Gauteng, but also served on the committee that looked into the state of municipalities in Gauteng, which gave me further exposure in the state of governance within the municipalities, particularly in the metros of this country. I then moved as Deputy Public Protector, a position I still hold and honor dearly, where I then worked in the Office of the Public Protector as a deputy. There I was exposed to the governance and operations of the Office of the Public Protector. I was also exposed to acting as the Public Protector in 2021. I was able to release reports, about 14 reports of my own accord, but also it gave me the opportunity to know the institution deeper, to understand the people behind the work of the Public Protector. Furthermore, on the unfaithful night of the 9th of June, I was bestowed with acting as Public Protector to date. Unlike other people who would arrive at the Office of the Public Protector with a plan, having had the opportunity to probably put together a vision, I didn't have that. I had to dive in and take charge and lead during a huge crisis that befell the Office of the Public Protector and be able to instill confidence into the staff of the Public Protector. On the first day, I held a staff meeting, but all is well. The institute will continue with its mentioning the institution. What is critical on the work that we've done, we've managed to finalize the analysis of jurisprudence that has shaped our mandate to date, and we have accordingly also looked into the developments within our country which affect the Public Protector Act, and we have finalized and submitted our proposed amendments to the Department of Justice. And further to that, we have also made some policy changes within the institution to ensure that we strengthen quality assurance, we strengthen our investigations, and we are in line with the law which has been set even by the highest courts, and that at least we move towards being fit for purpose as an institution. But most importantly, Chair, I am really heartened by the observations of the Constitutional Court in the recent judgment regarding the suspension of the Public Protector, where the court observed that on the basis of the affidavit that I had submitted to the Western Cape High Court, that the institution actually seemed to be conducting its core business well.
Thank you so much. And can we, do you confirm that the disclosures you made in the questionnaire, do you confirm the disclosures you made in the questionnaire?
I confirm, Chairperson.
Is there anything else you want to disclose or explain?
Nothing further, Chairperson. Thank you.
Thank you. Under what circumstances does the acting terminate?
It terminates under the circumstances that there is a permanent Public Protector.
So until this committee and the President fill, let me say until the President fill the position.
Indeed, Chairperson.
Thank you. All right. So you will have the opportunity with their colleagues. So they each have 7 minutes with you. Sorry. Well, no, please don't say that, because there are 2 members who are owing me 2 minutes. So it's an opportunity to deduct those 2 minutes. Okay. Now I start the 8 minutes. In the 8 minutes, it's a two-way conversation. All right? I'm not going to interrupt. Right. I start with Honorable. What do I start with? I start with Honorable Tlhape.
No, thank you, Chair. Thanks for the honor. Good afternoon, Advocate Gcaleka.
Good afternoon, Honorable Chape.
Yeah, let's go to your questionnaire. You have identified lack of economic growth as one of the key challenges inhibiting growth of our economy. What are the main reasons for this lack of growth in the economy? And what, in your opinion, should the role of the PP be in ensuring inclusive economic growth?
Honorable Chape, if I just want to start on the substantiated facts. The IMF releases its statement consistently on the country upon assessing the country. And part of the statement reflects that government fails to implement governance reforms. And as a result, the systems remain vulnerable to corruption. Now, that is one of the main factors. But as a country, we have an historical background of poverty, inequality. Therefore, those are some of the factors that have contributed. But most importantly, we come from a state of COVID-19, which also had a huge bearing on unemployment, on inequality, on poverty within our country. Therefore, for me, those are the main factors that really affect the growth of our economy. The Office of the Public Protector is very clear in line with its mandate that it is to investigate maladministration. So in addressing the issues of corruption, the maladministration that gives rise to the corruption within our country and the powers that we have, if at least government would cooperate in regard to the implementation of the remedial action, because most of our remedial actions are reformative. For instance, if you look at the non-implementation of the Financial Action Task Force recommendations which resulted in the country being grey-listed, those are part of the factors that actually resulted in the low or close to non-growth in the economy. Now, this is also supporting the fact that governance reforms are not being implemented, not just those of the public protector.
I'm sorry to interject. Thank you, because we have some few questions. We just have 8 minutes between us. Now, in your opening remarks, you touched on being exposed to the socio-economic issues of our people. What, in your view, is the reason for the rising cost of living, and what measures should be employed to curb this?
Obviously, when there's low economic growth, there would be a rise in the cost of living. For instance, the inflation rate would go higher. Also, the unemployment and the other factors which I have mentioned.
Advocate the rationality, reasonableness, and proportionality are critical legal principles that impact on legality. What is your understanding of testing rationality, reasonableness, and proportionality? And we can give examples.
When applying a discretion, the principle of legality applies. And therefore, in doing so, this principle, it's actually a constitutional control to ensure that functionaries exercise public power in a manner that is procedurally fair, in a manner that is reasonable, and in a manner that it is legal, to ensure that it doesn't abuse its power and also it doesn't infringe upon rights. Now, we've had several judgments as the Office of the Public Protector against us in this respect, and in one of them, in the matter of Mbina Mtembu versus the Public Protector, the principle of legality also came up, where the court found that we had to show that there was irrationality and disproportionality in the exercise of the public power. But further that, in the matter of the South African Reserve Bank, the issue of the manner in which the Public Protector exercised her discretionary powers came up. And the court said, if the discretion is exercised in a true form, the courts would not willy-nilly interfere with that discretion. And furthermore, that if you can prove that the options that you've opted for are legally permissible options. So basically, this is a constitutional imperative that is there to protect those against the abuse of public power.
Advocate, the Public Protector Act bestows powers to the Public Protector to delegate certain responsibilities to the Deputy Public Protector. What role will you delegate to your deputy if you are appointed? And do you think the deputies are given sufficient functions?
First and foremost, let me refer to the Public Protector in that respect. It says that the Public Protector will be assisted by the Deputy Public Protector and staff in the Office of the Public Protector. And further, that in exercising the powers, the Public Protector must ensure that it sets steps which are necessary to ensure that the Public Protector is independent, that it exercises its power impartially, justly, but also that it is able to conduct proper investigations. Now, in delegating powers to the Deputy Public Protector, firstly, for me, and if you look at the Kaida Asmal report, it is an internal governance issue, where you have to assess the work of the institution. Secondly, the exposure of the Deputy Public Protector. What are they exposed to? What is their experience? But also, what is their interest? So that also you help them in their interest. So I would delegate most of the powers to the Deputy Public Protector, but also I would ensure, because we've got standard operating procedures and guidelines of investigations, but the line of governance matters within the institution. So I would ensure that besides what would be delegated to the Deputy Public Protector in line with their expertise at the time, whilst they are abreasting themselves of the operations and the governance of the institution, but I would expose them to the entire work of the institution that comes through to the Public Protector, because it is important that we realize what is envisaged in the Public Protector Act, that the Public Protector must be assisted by the Deputy Public Protector, and there's no limitations in respect of that. And that is also to ensure independence, it is to ensure impartiality, but most importantly, that there is another eye at that level that is able to look into the matter before the Public Protector does.
On our last minute, how will you position the PPSA to enhance the oversight and legislative mandate of Parliament?
What is critical, it's something that we've actually discussed as an institution, is the issue of data and analytics, which we currently lack, but we are working on and we are trying to get it internally. Firstly, the SALGA produces data on public protest, for instance, throughout the municipal areas, and also the Statistician General releases data, in respect of the state of the country. Now, it is important to look at those vis-a-vis the petitions that go through to Parliament as well as the legislature, to look into whether there is a correlation between this data and the petitions that are being received, and whether they are being dealt with timelessly and so forth, and whether they are not the ones which lead to some of the deficiencies which leads into protests, but also to ensure that we are able to have that constant oversight into Parliament and be proactive rather than the reactive role that we currently play.
Thank you.
Thank you, Chair.
Thank you so much. Advocate Bredenbach.
Thank you, Chair. Thanks. Good afternoon, Mr. Gcaleka.
Good afternoon, Honourable Breitenbach.
Mr. Chair, I declare up front that I know the candidate, in as much as we both were employed at the National Prosecuting Authority at the same time, or our times there overlapped, and I've had certain dealings with her at the Public Protector's Office. I don't believe that I'm biased one way or the other.
Thank you.
In your view, what are the two most important characteristics of a public protector?
public protector must have a judicious temperament. They must be utmostly honest. They must have integrity.
Okay, thank you. Now, let's deal with the National Prosecuting Authority history first. To the best of my recollection, you were the chairperson of the Prosecutors Association?
Indeed.
During the tenure of, amongst others, Menzi Simelane.
Indeed.
And the association under your leadership, and I believe you yourself were quite vocally supportive of Simelane.
I was supportive of the transformation agenda, which he stood for. It is an agenda I still support, even in the Office of the Public Protector. It is an agenda that I have stood by even then. Any form of racism, whether it is against any other race against the other, I will stand against, and I would support anyone in that aspect, and I have done so even where I am at today.
Okay, that's neatly deflected, but that wasn't his only agenda, and we both know it. And everyone else in this room knows it. His agenda is, and his legacy at the NPA.
Sorry, but he's not here to defend himself.
Simelane.
Are you talking about, referring to Simelane?
I'm talking about Menzi Simelane. And he doesn't need to be here to defend himself. He's been found not fit and proper in a court of law.
I'm saying before you is the candidate, but please go ahead.
So Simelane was found by a court to be not fit and proper, and his agenda at the NPA was one of destruction, and we're both aware of that. So his agenda wasn't only transformation, and my interest is more in your support of his other agenda.
I couldn't have been in support of any other agenda. At the time, I didn't serve on the ExCo of the National Prosecuting Authority. I wasn't part of any decision-making of the National Prosecuting Authority. I had no idea of any of his other agendas. I did not know Advocate Simelane from a personal perspective. I only knew him as the National Director of Public Prosecutions. And my engagements with him were in meetings, in office meetings, and regarding challenges that we had at the South Gauteng division regarding racism and issues of transformation in particular.
His agenda to disband specialist units and scatter specialist skills to the far corners of the earth. You had no difficulty with that, and neither did the organization that you chaired.
I was not part of any of the decisions that Advocate Simelane embarked on. We were not consulted as the Society of State Advocates regarding the decisions that Advocate Simelane had embarked on. And as an association, and is what you might be well aware of, Honorable Breitenbach, is that you act on the mandate of your members.
Neither did yourself or the association have anything to say about Jiba, who was similarly found to be not fit and proper.
I was not the chairperson of the Society of State Advocates at the time. I had my own challenges at the National Prosecuting at the time, which arose from my initiation of the prosecution of Mr. Richard Mdluli.
Quite. So, that's being gotten out of the way. What is your understanding to the extent to which an administrative decision is susceptible to review under South African constitutional order?
Well, the decision is susceptible to review. Once more, I will reflect on the principle of legality, particularly that of the Public Protector, because firstly, the Public Protector needs to establish jurisdiction and thereafter apply its discretion. Now, the discretion needs to be in line with what is envisaged in the Constitution. It needs to be applied in a manner, as I have stated, that is just, that is reasonable, and that is in line with the law. The Constitution is the supreme law of the country, so every decision that is being taken, it must be in line with the supremacy of the Constitution. As well, even if it is in line with the law, that law must be in line with the Constitution, because it must ensure that there is fairness, there is equality in the execution of that particular decision, and it doesn't infringe on any other rights.
Okay, thank you. I must ask you to try and be brief because we only have a short period of time. From where does the court derive its powers to review administrative action?
Administrative action, it derives from PAJA.
In your questionnaire, I don't know if you have one with you, on page 9, under the heading redress. You've said that as the Public Protector, one of my priorities would be to continue to monitor the implementation of our remedial action, as I have already begun engaging the Presidency and the Speaker of the National Assembly to provide periodic implementation reports to the Public Protector. Can you just expand on that, please?
The Zondo Commission derives from the remedial action of the Public Protector under the leadership of Advocate Madonsela, where part of the remedies was that the President should set up a commission of inquiry to further investigate the matters that the Public Protector had sort of made preliminary views on, because she could not continue with further investigation because of a lack of resources. So therefore, the Zondo Commission is a remedial action of the Public Protector, and we believe that it rests upon us to then follow up on the implementation as same as the Zondo Commission was a mere commission and it ceased its existence at the time when the commission finished its work.
Thank you, Chair. I'm done.
Thank you very much. The next person is Honorable Maudwe.
Thank you, Chair. Good afternoon, ma'am.
Good afternoon, Honorable Mountain.
How are you?
I'm very well, thank you. And how do you do?
Good. So we've seen reports that you were elected as a leader of one of the organs of the ANC at some point, and you also served in the office of the Minister of Home Affairs and Treasury in the political office. How up to date is your membership of the ANC?
I possess no membership of the ANC of any other political party.
Since when?
I think it's about a decade now.
Okay. And then we've seen reports last week from the South African Reserve Bank that says that at their disposal there's no transaction that they can find between with Phala Phala farm. Your report, page 11 of your final report, and 241, says that, and I quote, you suggested that the 10 million located in Tawanyoni is from a private cash transaction. Do you still stand by that?
The report by the Reserve Bank is that there was no concluded sale between the buyer and the seller. Our report and our investigations did not investigate the sale because we do not have the powers to do so. It is a private matter that doesn't fall within the ambits of the Public Protector. Our role and our mandate is to investigate state affairs.
But you said it emanates from a private cash transaction. I'm asking, do you still stand by that?
Yes, I stand by it because we didn't say it is a sale. We didn't confirm that there was a legal sale which took place. We worked on what was before us, but ours was to deal with the issues that involves public administration and which were also regulated in terms of the Executive Ethics Members Act, and not the sale, or to confirm whether there was a sale or not and whether the sale took the form of being perfected or finalized. That was not in our mandate, and it is not what we investigated.
I'll come to the ethics question later. Where were you born?
I was born in Johannesburg.
And KZN?
My home is in KZN, previously the Eastern Cape, but it was then redemarcated into KwaZulu-Natal.
So before you were appointed as the advisor of the former Minister of Home Affairs, there's a security screening that was done, and you failed it the first time around. Why?
The security?
Clearance or security screening.
I've never failed the security screening.
Okay. What is your interpretation of the term ethics? You spoke about it earlier on.
The interpretation of the term ethics, basically, it is the character of one the exercise that they would perform and how they would perform it, which would have to be moral. Even if there is no regulation in that regard, one would have to do what is right. What is not, might not be necessarily regulated by law, but it is right in terms of public morals, the society in which we are in, and in good faith.
Do you think you're an ethical person?
Indeed, I am.
Why? What makes you think that?
I believe I am an ethical person because that is how I conduct myself, that is my characteristic as a human being, and that is how I have performed my duties from the first day I was employed to date.
Would you consider an ethical conduct in a situation where you abruptly terminate your funding for the public protector?
Would you kindly elaborate on that?
So you terminated your funding towards the legal fees of the public protector. Would you consider that an ethical conduct?
Of course, yes. It is in line with the Constitution. As a person who is vested with the exercise of public power, Section 195 of the Constitution states that I need to do so in a manner that is economical, that is efficient and effective. And having done that, it is in line with the Constitution, it is in line with my roles and responsibilities as the executive authority or accounting authority of Public Protector South Africa, where I have to take in line, have oversight over governance and the finances of the Public Protector and act in the best interest of the institution in line with what is budgeted for and what the institution can afford.
Do you believe you are equipped with to execute the responsibilities of the Office of the Public Protector in strict adherence to the law?
Having acted in this position and having been the Deputy Public Protector, I've been with the office for over 3.5 years. Indeed, I believe so. I have done so with the collective that I lead, and we have done so to the best of our abilities in line with the law and other legal prescripts, and we have done so ethically and with integrity.
Does that include submission of reports on time?
Submission of reports is in line, firstly, with the capacity and the capability of the institution, looking into the complexity of the particular matter, but of course looking into the legal prescripts which are applicable to that matter, and whether there is adherence to the investigation plan and so forth. So it is a multifaceted of issues that one has to look into, and where one is unable to submit a report on time, one follows the applicable prescripts of what needs to be done in such instances.
How long did it take you to release the Phala Phala report?
It took us about a year to
Why?
release the Phala Phala report. First and foremost, if you would go back even into the presentation that Advocate Mkwebane had done to the cabinet, where she stated very clearly that because of the resources, human resource and the financial resources of the public protector was unable to conclude EMEA matters within the 30-day period. However, it is not illegal not to conclude within the 30-day period, because the Act makes further provision that where the public protector is unable to conclude within 30 days, they must then report to the next level. If it is the president, we report it to the speaker, even though there is no provision for that within EMEA, and therefore there was no law that was infringed. And furthermore, there hasn't been a single EMEA case by the public protector that has been concluded within 30 days. If you look into the precedent, in fact, Phala Phala is one of the matters which was concluded speedily within the resources that we had, looking into the complexity of the matter, the amount of evidence that we had to
I'm running out of
accumulate
time. I want to
into the
move to your
matter.
next question.
I just wanted to adequately answer your
You
question.
can ask Chairperson to give
Honourable.
more time, but I don't have time. So what's your interpretation of Section 96.2 of the Constitution, which relates to the members of the Cabinet?
It is that we need to ensure, we are also vested with that particular section in our investigations. We need to ensure that members of the cabinet conduct themselves ethically.
Including the President?
Including the President.
Yes. Continue.
Indeed. Ethically in exercising their public power and duties.
And that they can't undertake any other paid work.
Indeed so, the Constitution states so, and so does the Act. They cannot undertake any paid work.
What's your comment on the Phala Phala one, where the president himself said the money was stolen from his firm?
Honorable, if you look at case law that is there, I will make an example with the case of the former Premier of the Western Cape, Zilla, where the court said, when conducting an investigation where statements have been made, it needs to be contextualized. You need to look into what would be a reasonable person with an ordinary intellectual mind. So not just, there must be an ordinary intellect. How would they interpret that? Now, as an investigation authority or body, we had to conduct investigation, look into the total circumstances, look into the law, and then come up with what had taken place. Would that be described as paid work or not? And we came to the conclusion that it is, in fact, a financial interest and not paid work.
And you still stand by that it's just a financial transaction?
Indeed.
No further questions.
Thank you very much, Honorable Maudu. Inkosi Buthelezi, over to you in the visit.
Thank you, Chair. Greetings, Advocate. I've got two questions for you, and my questions are very brief, and I expect such answers. In your position as a Deputy Public Protector, what gaps have you identified in the management of the office, and what limitations did you face which restricted you from addressing those gaps? If you are now given a opportunity to serve as the Public Protector, what will you do to address those?
First and foremost, the gaps that I identified is that there was no flow in relationship. There was no collegial relationship between the Public Protector, and this is now the private office that I'm speaking about, not just the individual, and the institution. Secondly, the gaps that I identified is that the institution was not doing continuous reviews on itself as a legal institution. And the third gap, amongst many others, was that there was no culture of learning, training, and development within the institution. The limitations that I faced as the Deputy Public Protector, first and foremost, is that I was not the final decision maker on the issues. I did do an assessment, I identified the gaps, and I brought those to the attention of the Public Protector. Now, what I have already done as the acting Public Protector is that first and foremost, even at the time when I was acting, I had purchased books for the library, both e-books and books that would be at the library to ensure that at least we develop some culture of learning within the institution. But secondly, what I've done now during my acting period was to ensure that we refresh and upskill our research and library capacity, which the University of KwaZulu-Natal has assisted us with. And what I've further done, I've inculcated the culture of the NPA, where there's really no barrier between the head of the institution and the staff, and open argument and discussions on legal aspects.
Okay. What do you consider as your greatest regret in the course of executing your duties that you will try to avoid in the future?
Impatience. I coming from the outside, and when you go into an institution, you go in with assumptions that you expect the institution to be at a certain level, and therefore things are supposed to flow at a certain level. And therefore, I became a little bit impatient, particularly in my first year at the Public Protector. But I must say, I have grown immensely, and I have learned to walk with the team, and even the slowest member of the team, and be able to lift them up to be at the level of at least the middle member of the team.
You consider yourself a very strong leader? Not easily influenced? If that's the case, can you make reference to a particular instance where this has been proven?
Indeed, I am a strong leader because I believe in collaborative leadership. I do not lead alone. The instance where this has happened, it was when there was a political march to the office of the Public Protector that was led by the Economic Freedom Front. to
Freedom
get
fighters.
freedom fighters, apologies. Apologies.
But nothing to do with
for that.
front.
Economic freedom fighters together with other parties in parliament. In that instance, I had to take the front line.
Okay.
I had to be able to be resilient and to be courageous to ensure that the institution stands by its independence, it stands by its impartiality, and it does its work without any fear, favor, or prejudice.
Okay. We have made reference to working in a collective, I think twice. What value do you think is derived rather from synergism?
What value is derived from there, first and foremost, it's extensive and proper investigations in respect of our work, but also you minimize the risks of mistakes. But looking at the history of our institution is that you build confidence, you build teamwork, you build courage amongst your team members, but most importantly, you inculcate the culture of independence and impartiality because there's sufficient checks and balances and due diligence and peer review that takes place.
Okay, my last question, Chair. Having served alongside the outgoing Public Protector and experiencing firsthand the impact of Section 194 inquiry and the public perception and trust in the impartiality of the office, how would you work to restore the public trust of the office should you be appointed?
What is critical is, I'm going to refer back to Section 3 of the Public Protector Act. What is envisaged there is that the Public Protector shall not work alone. The Public Protector must work with the team that it is there, both in core business as well as administratively. But secondly is that the Public Protector must ensure that there is necessary steps that are put in place to ensure that the work of the institution is shielded. There's independence, there's impartiality, and it is done so without any fear or favor. But most importantly, I would go back to the Mail and Guardian case, which was confirmed by the case of the Minister of Agriculture and Fisheries, that you need to stick to your investigative methodology when it comes to investigations. Investigations have to be done thoroughly. There has to be checks and balances investigations. You need to do your work with an open mind. But also recently, as the Constitutional Court said, you must not approach your work with any suspicion. As the Office of the Public Protector, apply the principles and the values of the Constitution of treating every person equally when they come before you and treating every matter as such. But most importantly, it is to build a strong team that would even protect you when you are not looking, that would even be able to pick up the blind spots from you as a leader. But my philosophy is that when somebody walks into a room and we're busy with quality assurance, they must not be able to pick up who is the leader here, but they must be able to pick up that there is a group of investigators who are vigorously critiquing one another's work to come up with sustainable solutions.
Thank you, Chair. I left no minute for anyone.
Thank you very much. It's Honorable Tape. Oh, you're done. Honorable Lesoma. Over to you.
No, let me not make that thing. But nevertheless, Chair, good afternoon, Advocate.
Good afternoon, Honourable Member.
Thank you. Earlier on, when you were responding to one of my colleagues' questions, it was around transformation. Is transformation limited to warm bodies and faces in your own understanding and perception?
Not at all. Transformation goes as far as systems. Transformation goes as far as decision making. And in our instance, it is in respect of our remedial action, in that in the remedial actions that we take, we need to make sure that our remedial actions are transformative and also that they are developmental in nature.
Okay. as an acting PPSA, are there any highlights of the cases that you would have in this short space of time that started to work on, or you have concluded as a crossover from the incumbent that you think that are highlights that you can showcase? For an example, just give us one, noting that you are working as a collective.
Indeed, the highlight of the cases that I have worked on was the investigation into the state of the public healthcare system in South Africa. It was during the high time of COVID-19 in our country. I was acting public protector at the time. Advocate Tumkwebane was on sabbatical. Together with the team of Public Protector South Africa, we left our homes during high lockdown and took the risks to face what was happening within the public healthcare systems when the media blew the whistle on the conditions under which the doctors were working in, but also the conditions of the patients and the conditions of the hospitals themselves. We were able to quickly produce an intervention report so that at least government can start implementing some of the systemic issues that we had picked up at the time, but also most importantly to try and save lives, particularly those of the healthcare workers who were saving the lives of the people of South Africa. That for me is a case that really touched me, but also the courage that the public protector staff showed by being able to go out there when death was facing them.
Okay. In your response, you spoke to systems, and currently you've got a business plan and all that. Probably also you are envisaging, if you are fortunate enough, not lucky, get appointed to this position. What new systems that you will employ to ensure that the turnaround, which is cost effective, you will employ, ideally?
We've already have the case management system, which actually became into full effect on the 1st of April this year. That system indeed is assisting us, and we are continuing to upgrade the system, because this is one thing that we are doing internally, and therefore it is a work in progress. But the other work that we have done in respect of our systems is also to ensure that our complaints handling is also done electronically, but further that we have upgraded our complaints forms to be more detailed so that investigators do not spend much more time locking issues and consulting with complainants. And furthermore, which is important that I would like to raise kindly, Chairperson, is also the reviewing of our assessments, and that I have actually employed a method where our executive managers are the ones who are doing the assessments of the cases, whereas before it was done at a much junior level. This is to mitigate the risk of a matter being investigated over a longer period of time.
Thank you very much. You have identified one of the key challenges, that there is trust deficit to the PPSA office, not the individual, and also between government and citizens. What are the basis of this, and what becomes the role of the PP in correcting those deficits?
Firstly, as the Public Protector Office, it is important that in the manner in which we take our decisions becomes in a manner that is of integrity. Our reports must be reports of integrity. But secondly is that our remedial actions must be implementable. Now that starts with us in the process and the procedure which we apply in arriving at the end, in taking the remedial action, that it must be implementable. But in respect of government, the issue is accountability and responsiveness, and being in touch with the people who have elected the government. We have found that to be a major challenge, and the issues of undue delay in responding to the challenges that the people are raising. And finally as well, the oversight by the legislature, which is not as effective as it's supposed to be.
Okay. The last one, Chair. In your own, it's got nothing to do with us. Your view, I just want to get your view in terms of the current government. Did it make a mistake not to do an exodus in terms of the public servants and have the new public servants, because it seems like it's a crime. That's my view, but I want to get your view. If you serve the current government, as it were, is it fair for public technocrats, as it were?
Not at all.
The perception that I have.
Not at all. First and foremost, our country has laws. So every action needs to be in line with the laws. There's the Basic Conditions of Employment Act, there's the Labor Relations Act, within which every government or every individual exercising public power needs to subject themselves in respect of employees. My view is that employees who work for government are supposed to be professionals and ethical people who are actually serving the country and the people in the country, but not individuals, not the political dispensation, but who serve in line with the constitution of the country.
The AG's report says that you have overspent in terms of your budget in the year under review. How would you ensure that you change that situation? Thank you, Chair, and I'm done.
Looking at the issues raised by the AG, it's historical issues of the legal fees surrounding the Office of the Public Protector on litigation, but also the cases, but of the litigation of the Public Protector. What we are currently doing, we've reviewed our governance system in our legal department as well as in our finance, but also we are ensuring that we are conducting our investigations in such a manner that we prevent the litigation at the scale at which it was at, and our reports will be able to defend themselves. Thank you.
Thank you very much. Honorable Hon, you are owing me 2 minutes. It's a payback time.
No. I have received another minute, so that would make it 9.
Okay, sure. Back to you.
Thank you. Good afternoon, Mr. Gcaleka.
Good afternoon, Honorable Hon.
Yeah, so when you came to be interviewed as the Deputy Public Protector, we touched base on your period with ex-Minister Malusi Gigaba. Since then, we've had the benefit of the Zondo Commission costing this country R1 billion, but which favored us with massive amounts of information, amongst others, about your former principal. So I want to revisit your period there and again ask you, did you at the time advise the minister about his close relations with the Guptas and the fact that it exposed him and the country by extension to impropriety, to borrow the words that's used in the Constitution in respect of the Public Protector?
Honorable Hon, at the time when I was interviewed for the Deputy Public Protector position, I was very clear that at the time when I worked with Mr. Gigaba, I had no knowledge of his relationship with the Guptas. During my work with him, I had no knowledge of the Guptas. They have never come to the office. I have never seen them. I had never known of his relationship with them. At the time when the issue came up, it came up in the public. And I asked him about it, and he denied any association with the Gupta family.
Okay, and looking back, a professional special advisor, should you have not, given the fact that the allegations at least were already in the public domain, have acted more proactively to protect your minister? In
which way, Honorable Hon, if you could kindly elaborate, to protect him in which way?
Protect him against what happened ultimately. He lost his position in the executive, primarily as a consequence of this relationship.
It's not my duty, particularly as an advisor, to protect a minister. The duty of an advisor is to advise the minister in line with his duties in serving the Republic, not on anything personal, because an advisor is employed in terms of Section 12A of the Public Service Act, and it is not a personal advisor, and the advisor performs their duties in line with the law in respect of the advices that an advisor would provide to the minister.
Okay, I'll park that issue. I want to go to your answer around the review of administrative action, specifically in the context of the work of the Public Protector, and what interested me is the fact that you said that reasonableness, rationality, and proportionality in that context is specifically relevant for the Public Protector Office in the exercise of a discretion. Can you explain to us how, when you embark on an investigation, there is a room for you to be confronted with a discretion?
Yes, the Public Protector, for instance, after it has been decided that the Public Protector has jurisdiction in a matter, it then becomes the Public Protector's discretion on the form that the investigation takes in respect of that matter. For instance, where you've got jurisdiction, and this has been confirmed in the GEMS matter, where you've got jurisdiction, you then have to look into the totality of your matters and say, are you going to investigate everything that is before you? Now, the GEMS judgment actually says that the Public Protector has a discretion, for instance, to remit other matters to other public bodies which have the authority over those matters. And
then,
that is...
Yeah, thank you. That's a satisfactory answer. But then once you've embarked on an investigation, you've now exercised your discretion, say, okay, I'm going to take this on board. Where can a discretion then come into play, if at all?
Once you are investigating your particular matter, now what comes into play is the legalities that you face within that matter. It is on the methodology, on how you apply that particular methodology, which witnesses are relevant and which witnesses are going to assist you in your investigations, or any other evidence which would assist you to come to a final decision which is in line with the law.
Is the decision to decide which witnesses are relevant discretionary in nature?
Well, it is discretionary.
Are you quite sure?
Yes.
Okay. Then I want to come to your section 196. You've already answered some questions on it. What is the lodestar, the guiding principle now thrashed out by our courts of the method that is to be used for a proper interpretation of any statute or law?
The proper interpretation of any statute of the law, firstly, the supreme law of the country is the Constitution. So in interpreting that law, you need to look at what were the objects of the Constitution, what is the principle and the values and the spirit of the Constitution in line with that particular law.
Maybe we're missing one another. There is a court case of the Supreme Court of Appeal which is now settled in the constitutional era. What is the approach anyone who interprets a law must take? What is that case?
Recently, there is the case of the SARS, which the court took in interpretation of the Tax Administration Act.
Are you aware of Natal Joint Municipal Pension Fund versus Endomeni?
No, I'm not aware of that case.
So that's actually the case, and the case says that context, you refer to context, must be given by the apparent purpose of a provision. Now, what's the purpose behind the provision in Section 196, which says the President and members of the Executive cannot have other paid work?
The purpose for that is to ensure that the duties that the Executive undertake become the primary duty, and that it is not overweighted by the secondary duty, which is the private interest, and further that there is no risk of a conflict between the primary duty and the personal interest.
Yeah, well, that the member of the Executive do not expose themselves to the potential of a risk.
Indeed.
Of conflict of interest.
Indeed.
So in your Phala Phala report, though, that second leg is nowhere to be found. Would you agree? You only say that ultimately the financial interests did not distract the President unduly from his primary responsibilities.
Not at all, Honourable Member. We discussed the issue of the conflict of interest in the Phala Phala report. Now, primarily what we need to look at, which we actually have interacted with, which has also been confirmed by the Constitutional Court in the recent case of the suspended public protector, whether there is a real risk. Now, there mustn't just be a suspicion or a far-fetched risk or any other potential which is not related on whether there is a real risk of a conflict of interest in the particular matter. And that we have interacted with in our report.
Okay. Lastly, how many reports have you been in charge of in terms of the investigation and bringing out the report, both as the deputy and now as acting, which has been finalized?
Well, I have signed 107 reports. I've interacted with more than that. The figures I do not have, but obviously those were not signed by me.
Okay, and how many of them have been taken on review?
We have 3.
And has any of them been finalized yet?
None of those have been finalized.
Okay, thank you.
I gave you 9. So, you took 9, you are right. Honourable Vessels?
Thank you, Chairperson. Good afternoon.
Good afternoon, Honourable.
You reflected on your time at the Department of Home Affairs. I want to go back to that as well, but more to, in general, your time at government departments, especially, it wasn't very long, but at the DPSA. Given that experience, what would you say is the root cause of the overall lack of service delivery, or let's say bad public service that we are experiencing?
Overall, the lack of efficient and effective service delivery, it starts with proper planning. It starts with proper planning, from the strategic planning, the implementation of the operational plannings, but also in ensuring that services are delivered equitably, but also budgeting in that respect is a challenge. But also the capacity and capability of public officials in understanding where we are as a country and what are the priorities. There's a lot of maladministration that takes place, but there is just where systems are not moving. But also there is a factor that each time when a new minister is appointed into a department, it is as if it is a totally new administration or it is a totally new department altogether. There is no continuity in terms of execution of responsibilities.
You say that one of your priorities currently, and if you are a successful candidate, will be to also focus on institutionalizing training at the Public Protector. Is there currently a lack of skilled staff members?
Indeed, there is inadequacy in terms of skilled staff members, and this has been confirmed by an organizational development study which we have done as an institution.
Are you under-resourced, understaffed currently as well?
We are under-resourced both in terms of human resource and financial resource.
What have you done during your tenure as acting Public Protector to make the institution more accessible for the public and for communities?
I've embarked on intensive stakeholder and outreach programs, particularly into the rural areas which have no access to the Public Protector in terms of technology. In terms of technology, we have, which is work that actually began before the Public Protector was suspended, but which we completed. where we've got an app where those who have means are able to access the Office of the Public Protector. And next week, Monday, we will actually be launching our Please Call Me app, which will enable those who do not have smartphones, who are underprivileged and do not have the financial resources to access us and send us a Please Call Me. We have also made use of stakeholders like Amakosi, so that we are able to access their constituencies. But we have also now approached business. For instance, we would want to have a drop box at ShopRite, at Checkers, in any other area, so that when a person goes to town, they are able to file a complaint at that instance and not necessarily look for the Office of the Public Protector.
I'm glad you're reflecting on that, because if I look at your priority of digitization and digitalization and digital transformation, then it feels to me as if you're leaving out the rural, majority of rural South Africans. But even Please Call Me's are in many instances inaccessible to a large part of our population. And even the Dropbox idea, how will you get a public protector accessible in those communities, in rural Eastern Cape, rural KwaZulu-Natal, where there's no cell phone signal, no electricity, no Checkers, no ShopRite?
We actually go to those areas. I have personally been to Ndabankulu, where the residences were being transported with a drum from one area to the other. They couldn't access service delivery because officials could not access their areas because of a lack of a bridge. We have been there as the Office of the Public Protector. We have been into an area in Umtata where the roads do not permit for people to walk through those roads, but we have been there. So we've got outreach program, and our outreach particularly focuses on those areas, indeed, Honourable Member, where at times there is no signal and where they are unable to use any other phone, but we are able to go there. But our program with Amakosi assists us to be able to access the rurals, because we are now planning on having drop boxes at the royal houses where people normally go, and they'll be able to access that.
Don't you also think the lack of confidence is due to the fact that people out there don't always understand? And I don't want to go into the debate that has been had on the Phala Phala report, but do you really think the people out there understand the reasoning that you are here in very technical legal terms explaining and have explained, but it's not really explained to the person out there, the reason?
We actually do. We work together with community radio stations, where we go on onto those community radio stations and explain our work in the languages that are understood by the people there, but as well as our pamphlets come in different South African languages, so we are able to have that accessibility with the people of South Africa.
One last question, because I think I'm out of time. You say that you would prioritize, and you spoke on it earlier, the legislative reform with regards to criminalization of the non-compliance with remedial action. But do you think that will really address the current non-response to the remedial action?
It's a multifaceted approach. So we have included that as one of the options. The other option, which we've also included, is for the Speaker of the National Assembly to have some mechanisms in place, so that once we submit the reports and the outstanding remedial action, that is able to then be filtered down to the committees, which will enforce their oversight. And that is a process that we are already doing. For instance, now we've been called by the Committee on Education as well as Sports to discuss our report with them because of that exercise. But what is most important for us is that from the time when you write an allegations letter to a public official or a public institution, start to discuss the remedial action in that respect. That should there be such a finding in respect of this act, this should be the kind of reforms. I must commend the Western Cape government as well as the Gauteng government in most instances where we actually put in place that mechanisms. Even before we finalize our report, they would have started to implement the reforms. But also in the Section 7.9, make sure that your reforms are in line with the powers that the other party is able to exercise when you make that remedial action.
Thank you very much. Thank you, Chair.
Thank you very much. Advocate Broidenbach will take leave. She has another engagement to attend to. Thank you very much. All right. So I carry her vote. Yeah. Right, we go to Mananiso.
Thank you, Chairperson, and welcome, Advocate.
Thank you, Honourable Manani.
My first question is with regards to you, actually as the acting PP, in terms of the issue of low morale of staff. I want to check with you, what have you done in terms of ensuring that there's team building programs and you keep the morale high of your staff?
Firstly, when I joined the Office of the Public Protector as the Deputy Public Protector, there was no employee wellness program at the Public Protector. And coming from environments of high stress as a result of the environment itself being a legal investigative environment, I know that stress is one of the highest triggers within that environment. I immediately made a recommendation to the Public Protector that we need to shift funds and ensure that we've got an employees wellness program. Now, we've taken advantage of that program immediately when I started acting by ensuring that there's an assessment of the environment and the conditions, and we are able to assist the employees, particularly those who've been heavily affected by the trauma, and the employees are actually making use of that. As we speak, we have the relevant company that is busy doing a psycho-emotional assessment. It has started with the executives. We will have that done for the managers and the entire staff, because it is important for us to know what is our psycho-emotional state as an institution, individually, the team, and as an entire institution, so that we put in place interventions. We have also done individual interventions for those who have approached the company. We've encouraged people to do so, but we want to have a holistic institutional approach to that, but we want to be informed by a proper assessment. But most importantly, we promote compassionate leadership, particularly considering the history of the institution, and the morale of the institution has increased. The Human Rights Commissioner for Kenya visited us on Tuesday. She actually says this is such a happy institution, having arrived, being received by colleagues and visited the other areas, which were impromptu visits, by the way. She said, this looks like a conducive working environment. The people here look happy. And indeed they do. Things have changed at the Office of the Public Protector. As a result, investigators even would argue wanting to have their names on the reports that we are producing. It then shows that the passion has increased, the energy has increased, and they are more than ever dedicated to serve the people of South Africa.
Okay. I want to give you an opportunity to sell yourself and confirm, if you were to be a public protector of this country, what are your special projects that you will bring forth in terms of addressing the issue of marginalized and vulnerable groups?
In the issue of addressing regarding the marginalized and vulnerable groups, first and foremost is to access them more, to intensify our outreach program in accessing them more, whether collectively or individually. No, it is to intensify that, but also to ensure that the remedial actions that we take are more developmental in respect of the challenges that they are facing. And by the way, I've already started a systemic investigation, which the team is busy with, that is looking into the systems within our justice system that are a hindrance in combating and preventing gender-based violence. The other systemic investigation is in respect of our maintenance system as a country, and the third one is in respect of our education system in South Africa, because education, for mostly of those who are disadvantaged, it is the gateway to economic liberty.
Okay. You make emphasis on the issue of corruption, maladministration. What is your plan for those who are repetitive offenders?
In our respect, I mean, a lot of governments, you find that we have done reports previously, but they continue to do the same act. The plan there again, we've put it in our proposals for the amendment of the Public Protector Act, that we actually regarded as a contempt of the public protector when an individual or a public official doesn't implement the remedial actions of the public protector, because if you actually implement the remedial actions, you are able to curb the maladministration. So that is the first one. But the second one is to work very closely with the legislature so that they optimally implement their oversight over the executive.
Okay. I want to check your understanding in terms of civic education, because all of you who came before us, you are telling us about awareness programs and things that you will bring forth in terms of people to know what is the work of the PPSA. However, nobody speaks about educating the society. So what is it that you can bring on that aspect?
In fact, we are starting off a program. We have met with the Black Lawyers Association, we have met with Saula, and we've also had discussions with the Faculty of Law in UNISA, and we are planning to expand this so that we are able to use people who are skilled on issues of rights, accessibility of the state, accessibility of us as the Office of the Public Protector. But because we've got limited resources, the issue of using the law clinics of the universities as a form of education and workshop in communities, because we would want to focus on people who actually live in those communities, who would be able to spend much greater time with those communities in respect of education.
Okay. On the issue of Chapter 9 institutions, right? What is it that you think it is the problem that all Chapter 9 institutions are not responsive to issues as supposed to, and what needs to be done?
The issue is the issue of capacity. I don't think it's necessarily not being responsive. Chapter 9 institutions are responsive, but because of the financial capacity as well as the human resource capacity, we are unable to be as speedy in terms of our response as we would like to be. But actually, Chapter 9 institutions are supposed to be reactive. So what does that require out of all of us? It's a better collaborative work amongst ourselves, civil society, business, and government, to ensure that we are able to pick up on the issues even before they are reported to us.
Okay. My last question, before the chair takes over. No, I'm within my time frame. Yeah. With your own understanding, I want you to take us in confidence on the issue of conflict resolution and conflict management, and bringing along the aspect of mediation.
Firstly, I'll start with conflict resolution. Conflict resolution is where you deal with the issues systemically. You want to discover what is the root cause of that particular issue, because the aim is to resolve it. Now, mediation is part of the mechanisms for conflict resolution, because you need to ensure that you bring together both parties, and the one who is mediating, you are impartial in respect of the issue concerned, and you are able to facilitate the mediation. But there must be harmony amongst the parties. You must ensure that they do reach consensus and there is no party that walks away aggrieved, so that you ensure that the issue is being resolved and not just managed in the instance of conflict management. Now, conflict management is where you put in place mechanisms to control and contain the particular challenge. Now, those mechanisms can vary from prescripts available, policies available, or even the higher authority available to ensure that at least there is some form of just keeping peace amongst the parties.
Deputy Public Protector. I now move to Honorable Makwanisha.
Thank you very much, Chair. Good afternoon, Advocate Gcaleka.
Good afternoon, Honorable Makwanisha.
Chair, I must declare that I do know Advocate Gcaleka since the time I was in the executive, and we also work together in the committee. She reports to the committee.
Noted.
Thank you very much. Advocate Gcaleka, how has the NPA honed you for the work you are doing now?
Would you kindly repeat that?
How has the NPA prepared you for the work you are doing now?
Firstly, as a prosecutor, you are vested with prosecutor-guided investigations. So in respect of conducting and guiding investigations, not necessarily the field work of investigations, there is a lot of work that prosecutors do in that respect. But also, as prosecutors, you work with communities, you go into communities, conducting education, awarenesses, outreaches into communities. I even used to train doctors on medical legal work. I used to train the police on investigations, and I also used to do training within the National Prosecuting Authority. But most importantly is the issue of performance management. I used to be in the national committee that dealt with performance management. So when there's a crisis in any of the offices throughout the country, I used to even chair that committee where we would go and assist and put in place interventions in terms of performance management. But most importantly, it's in respect of litigation.
Okay, well, thank you very much. And how has legal advising ministers helped you or honed you or prepared you for this role?
Firstly, it's to understand the public service much better, because in the NPA you don't deal much with administration, but it was for me to understand administration, for me to understand the role of an executive authority, but also the role of the executive authority in the form of the PFMA as an accounting authority, but basically on the reflections of the interface between the executive authority and the institution itself.
Okay. Do you believe that either the public protector or the investigator should take oath of office before they resume their work? If so, why so? If not so, why?
I strongly believe so. I think more than the constitutional and the legal imperatives that are there to uphold ethics, it is important that the public protector and the deputy public protector take oath of office. In fact, it is one of our proposals in the Public Protector Act. And the reason for that is to inculcate that culture of ethical conduct, of being truthful, and to perform the duties in line with the Constitution and the laws of the Republic. And where staff is concerned, I also believe that they should. And what we have done in the meantime to mitigate that, last year in October, we made staff members to actually sign a pledge to serve the people of South Africa truthfully, with integrity, to be responsive and to be accountable. And I have also just recently signed the ethics policy, which has been produced by the institution, where we are inculcating the ethics code in line with the Venice principles, which is the principles on the protection and the promotion of the ombudsman offices.
Okay. We know that we have a Public Protector Act that predates the Constitution.
Indeed.
And I think you have had time to apply yourselves on what needs to be changed.
Indeed.
So can you give me 5 areas, General, that you think that the legislature and the executive should assist to initiate a legislation to amend the Public Protector Act?
We've actually already, Honorable Makwanishe, submitted to the Department of Justice the proposals, and some of the proposals that we've put in place is the one of the oath of office, but the other one is to make a clear distinction between the public protector as the incumbent and the public protector as the institution. And furthermore, it is to align the Public Protector Act with the PFMA, where it clearly stipulates that the CEO is the accounting officer of the Public Protector. And furthermore, we make proposals regarding the whistleblowers, where we are putting in place more mechanisms where the Public Protector can assist with the protection of the whistleblowers. And the other factor, which is very critical to the independence of the Public Protector, is the funding model of the Public Protector, to ensure that we do have a separate vote as the Public Protector. There's several studies. There's the new National Party, but also there's the global standards on national human rights institutions that speaks on the funding part being a critical component when it comes to the independence of the Public Protector.
Thank you, Advocate Gcaleka. Thank you, Chair.
Thank you very much, Honorable Janchi. Thank you, Chair. Advocate Gcaleka, you can take the water. You've been speaking non-stop. Maybe the first point to raise, because I think a lot of my questions have been taken and you've responded to them even before you were asked. The first point to make, perhaps on a lighter note, out of these 8 candidates that we're interviewing, you seem to be the youngest of them, all of them. So if you are successful in this position, you're likely to be the youngest public protector. How does that make you feel?
Firstly, I think it would be something that, just not for me as a feeling, but it would be a statement to the country that younger leadership is what this country actually needs. The developing countries are becoming younger. It's only African countries that remain older, but also that
it's no reflection on us. Please ignore them, go ahead.
But firstly, that particularly an institution such as the Public Protector, it requires energy. It requires innovation. It requires creativity. But it also requires acceptance of the two contradictions between the young and the old, and be able to find middle ground in those in order to take the institution further.
And being a woman in a masculine society?
Being a woman, yeah, it's a difficult one. Because truly, my philosophy is that as women, you always have to work thrice as much as men work, you know. And I normally say, look at the corruption that has taken place in our country. Mostly it's men who have carried out that corruption, but it never goes into the name of men. Every man is taken as an individual, but a woman is taken as a collective. When things go wrong with a woman, it is then put onto each and every woman. So as a woman, basically what it means is that I need to ensure that I prove myself in order to affirm the leadership of women.
Maybe just to then conclude that this lighter note matter, because I want to take you back. You would have been much younger then when you're dealing with the Mdluli case. And I want you to tell us, in your belief of doing things without fear, without favor, and without prejudice, what really was your hope when you drove that and consistently so, knowing that you are dealing with a highly placed head of crime intelligence?
You know, interestingly, when I came into contact with that docket, it had 5 statements in it, and I didn't know whom or what I was dealing with. There was no name of the suspect. Guided the investigations, and 3 months later, when the docket came back, that's when I found out basically whom and what I was dealing with. But for me, it was to ensure that justice is done. I must be honest, it's one of the most emotional cases that I've ever dealt with, where you've actually seen how public power can actually be advanced and instill fear in families that are poor, a family that doesn't know where to go and how to go. And for me, was to ensure that justice is done, but so that people can believe that indeed all are equal in this country, no matter what position one holds.
Thank you. I want to go back to the Mail and Guardian case you told us about. And in that, I want to just situate Jafta J in him talking about this open inquiring mind, where he says you need to be open to all possibilities. But he creates these two contrasts, that you must have the mind that is not unduly suspicious, at the same time a mind that is not unduly believing. I want you to take that and place that in the Phala Phala investigation. Did that really materialize?
Indeed it did. It did materialize, because in the Phala Phala investigations, when I took it over, when I started acting, I made sure that I allow the investigators to do their work. First and foremost, in line with the Public Protector Act, I made sure that I take the necessary steps to ensure that there's independence, there's impartiality in the matter, and the matter is being dealt with without any prejudice to any party. There was one investigator into the matter. I strengthened the investigations. I included a senior investigator. I made sure that the executive manager responsible for the branch has oversight over the matter, and that the current CEO, who was the current COO, who was the acting COO at the time, made sure that she had direct oversight in that matter. But that I, as the acting public protector, receive that matter in terms of our standard operating procedures and investigative guides as an escalation. Not at any point have I gone down to find out what is happening in the matter. It was very critical for us, because we had to build trust as an institution, but we had to stay to the true form of independence of investigations. But what further happened into that matter is that each time the investigators escalated the matters, questions were put to ensure that we close the particular gaps in each and every matter. Mail and Guardian further says that the investigations should not be static, and we ensured that we even beef up our investigation methodology so that we ensure that we are able to deal with this matter in a proper investigation, an extensive investigation, but most importantly, removing who is involved and saying what are the actions and what are the legalities that we are dealing with as an institution.
Okay, thank you. Can you share with this panel and the country at large that is listening to you? You have a standing investigation method in the Public Protector. Just the key elements of that and the pillars of what you do and what you don't do, because I have a next question to that. Unfortunately for you, I'm not going to be asking what you do, I'm going to be asking what you're doing currently.
Indeed, we do have a standing investigation method. We have actually strengthened it. We have reviewed it. We have started, as I've said earlier on, to look into our complaints forms. Firstly, are they fit for purpose currently? You know, the jurisprudence around the Public Protector has developed immensely. Are our complaints forms speaking to that? Firstly, we found out that our complaint forms are not adequately addressing the issue of special circumstances, they are not sufficiently extracting the complaint out of the complainant. And we moved over to our assessment forms, because these then form part of the Rule 53 when a matter goes to court. Are we executing the delegations by the Public Protector in line with the delegation of authority and in line with the law? And we found that there were technical discrepancies. And by the way, these are the discrepancies which were also pointed out by the court. But we've also piloted the review of our structure, because we need to come before Parliament again if we are reviewing. But we have piloted the review of same to ensure that we strengthen our
Thank you. You can pause there. You can pause there.
Unfortunately, cannot accommodate a further question. I think you've exhausted your time.
Thank you.
Thank you.
Colleagues, thank you, thank you very much. It's 6 minutes past 4. I think we did well. We finished within time. Thank you very much for cooperation. Advocate Gcaleka, thank you very much for the time with us. Now at the conclusion, we can only say farewell, have a safe trip back home, and thank you, colleagues. So the colleagues are going to walk you out. Please, can you walk her out once we do our in-house things?
Thank you, Chairperson, and thank you to
No,
the honourable
just
members.
so that we conclude the time for Monday. Yes, Advocate Gcaleka, I'm sorry. You ready to say something?
I just wanted to thank you, Chairperson, and thank the panel. Thank you.
Thank you so much.